to? Good morning, dear colleagues. Those who need translation, please put on your headsets. And we are beginning our session on the development of competition law in the modern world. Within the framework of this session, we're expecting to discuss some of the aspects of the antitrust policy under contemporary economic conditions. Very often, a question arises about what this anti-monopoly policy should be like. Our goal is to define the main approaches emerging within the Russian Federation legislation and the legislation of the EU and other European countries. Approaches to regulating economic relations and the approaches that have been designed in the contemporary conditions in the area of antitrust legislation. Participants of this session are high-level professionals who specialize in anti-monopoly regulation. And I would like to introduce to you Mr. Kuandikov is chairman of the Agency on the Competition Protection from Kazakhstan. Larissa Kalanda is vice president of one of the largest oil companies, Rosneft. Oksana Gvazdilina is the judge of the Supreme Arbitrage Court of the Russian Federation, and she usually just participates in the cases, trials on antitrust crime. Then Artemyev is FAS leader. Zheny Frederick is chairperson of the Committee on Competition at OECD. Theodor Tanner is CEO of and president of Anti-Monopoly Committee of Austria. Giovanni Petruzella represents the Committee on Competition of the Republic of Italy. Dear colleagues, regardless of the fact that not everybody is here, but we are online, on the internet. And that's why I would like to start our discussion with the topic that is closely related with the international experience of anti-monopoly regulation. Giving the floor over to Frédéric Zheny.
Thank you very much, Mr. Chairman. I would like to offer 6 thoughts about competition law derived from the international experience, which we may want to keep in mind in this discussion. The first point is to note the proliferation of competition law throughout the world, which has been absolutely stunning in the last 15 to 20 years. We all know that the number of countries with the competition law roughly increased by 100%, and that there are now more than 120 jurisdictions in the world which have competition law. Now, as an economist, I teach my students that, of course, competition leads to more efficient markets and therefore to more economic development. And it's, in a sense, reassuring to see that so many jurisdictions have decided to adopt the competition law and to improve the quality and the working of their markets. Now, when I look at the evolution over the last 20 years, however, I realize that the main driver of the proliferation of competition law has not been the conviction or the understanding that competition improves market. It has more been the trade agenda, which has led to the elimination of anti-competitive trade instruments and the replacement of those instruments, such as anti-dumping, for example, and the replacement of those instruments by domestic competition law. So First thing to keep in mind, even though there has been a considerable proliferation of competition law throughout the world, it does not exactly mean that governments are always have a deep understanding of what competition really involves. Second observation is that competition law is, in each country, I think, a necessary tool to improve the working of the market economy, to bring economic efficiency, but it is not a sufficient tool. Yesterday there was an interesting discussion about the interface between intellectual property and competition law, and it became quite obvious that in the discussion that those two sets of laws have to be consistent to a certain extent with each other, or reconciled with each other, because there can be use of intellectual property law to actually restrict competition. Now, if we think about other areas, a country that has a bad bankruptcy law is not going to attract a lot of investment, and therefore is not going to attract a lot of newcomers, because a lot of people are going to be worried about getting their money back if something goes wrong. So, okay, bankruptcy law, contract law, ownership law, intellectual property law, international trade laws are all necessary complements to competition law to bring about more competition. Because even though competition law does its bit, I mean, competition is the result of a wider process. So the second issue is every country should have a set of consistent policies, and having a competition law or having a competition policy in itself is insufficient to bring about the benefits that we expect from competition. My third observation has to do with the nature of competition law, and I really have 2 points there. The first point is that there is a specificity of competition law. Everybody always claims that they are specific or they're different from the rest of the world, and so you may be a bit skeptical about why it is that competition law should be considered to be specific. But competition law, as far as I know, is the only law that we have which is derived from a theory. In this particular case, economic theory. When you take a competition law, it does not explain what competition is. It may explain what anti-competitive practices or illegal anti-competitive practices are, but it still doesn't tell you what competition is. And to find the meaning of competition, you have to go outside of the law and look at economic textbooks or economic explanation. This means that there's a particular challenge for judges and competition authorities because they have to function at 2 different levels, the legal level, but also the economic analysis level. Now, judges are not always very well prepared for this, for perfectly understandable reasons. So the role of experts and how the procedures of court proceedings can allow for a discussion between the experts of the party or the experts of the court, and the judges is really an important issue. Now, if you think about tort law, for example, nobody has to tell a judge what tort is. He knows that. This is in law. He doesn't have to go to another discipline to find the meaning of the law. So that's the specificity of competition law. Now, there is another aspect which is not specific, which is that competition law is a law, and a law is a political compromise. So that explains that competition laws in different countries do not have exactly the same provisions. For example, in the EU, we have very strong state aid provisions that do not exist in the US. We also have an interpretation of merger control, which is different from the one of the US, and the reason for this is that we have suffered, in general terms, from high levels of high level of concentrations in Europe. In South Africa, you have an exemption for anti-competitive mergers that promote or empower the blacks because of the long history of apartheid. So we should think about competition law and keep in mind the fact that those differences result from political compromises, which may evolve over time, by the way, but it means that competition law is not strictly similar in all countries. Now, of course, for businesses particularly for multinational businesses, that raises an issue. How do I deal with different competition laws in different countries? And this is the reason why there is so much importance in the area of competition on best practices, on trying to make the system converge. It's a slow process, but this is what UNCTAD is doing, this is what the ICN is doing, this is what the OECD is doing, trying to bring the countries to a closer understanding, common understanding of what the principles of competition law are. My fourth point is the impact of competition law. Even in the best theoretical world, competition is a long-term process that will, in the long term, bring about a better resource allocation and more efficiency. Now, the long term is a word that politicians usually don't like. They are not sure that they will be around in the long term, but they are sure that they want short-term results. And they get very impatient with competition authorities many times. This has been quite clear recently when there have been huge increases in price, oil, bread, or whatever, wheat. And competition laws in many countries have been called by ministers of finance and say, what are you doing about this increase in price? And when competition law official explained that, first of all, we're going to look at it, but it's going to be a long process, and B, it may have nothing to do with competition, there's a lot of tendency for ministers to be impatient, to say you're useless. So there's a particular challenge for competition authorities to show the results, to show that they are, in fact, delivering what competition is supposed to be delivering, which is better functioning markets. This is a long-term project, and it means that the advocacy function of competition authority is quite difficult, and I will come back to this in a second. The fifth and next to last point is the relationship between enforcement and advocacy. Markets don't function well just because you have a competition law. You have to have consumers who understand that making competition work in the end is beneficial to them. This is not intuitive. A lot of consumers think that it's much better when government controls the prices and the price stays at a low level. And when you tell consumers, go and shop around, make comparisons, they tend to say, well, you know, there's a huge cost for me, why should I do that? I mean, I don't particularly want to do that. Businesses are not necessarily convinced always of the benefit of competition for different reasons. So it means that if enforcement is very important to show that there is determination about competition law and that there's going to be severe penalties for people who engage in anti-competitive practices, advocacy, making people understand what the benefits could be of competition law and competition law and active participation in market is equally important. Equally, advocacy with government is very important. Why? Because a lot of obstacles to competition are not really due to individual behavior, but they are due to regulations which are preventing, in fact, either entry into some sectors or the free play of the economy. So the advocacy function of competition authority is of considerable importance, even if enforcement is strictly necessary, because advocacy without enforcement is not terribly convincing, but enforcement without advocacy may not deliver all the results. And my last theme is from enforcement to compliance. As I look at the OECD Competition Committee and see what has been the evolving mood, a lot of competition authorities have gained quite a bit of experience in enforcing and in advocating, and have realized that nevertheless there are still anti-competitive practices being committed by firms. And even worse, sometimes it's the same firms that keep on violating competition law. And that raises a question, is enforcement sufficient to get compliance? Or is there something else besides strong enforcement that would be necessary as a complement to enforcement? And over the last few years, competition, of course, has not been the same, the only area where this issue has come up. Corruption, for example, has been also an area where it has come up, but there are various fields. So the discussion has shifted, in a sense, from strong enforcement, on which everybody agrees, to how do we get compliance. What has been very noticeable is that in a number of very large firms throughout the world, the status of the in-house lawyer has risen. there's been more and more understanding that it was of strategic importance to the businesses to have compliance with competition law, with securities law, with anti-corruption laws, etc., and that therefore this function was in the interest of firms. This is likely to improve the level of compliance. There are also talks between specialists in different fields on how do you get compliance, what is a good compliance program, how can one promote compliance, because it's always much better to make sure that there are no violations rather than coming after the violation has been committed and trying to repair the damage. So those were my initial observations. Thank you.
Thank you very much, Mr. Genie. In fact, the provisions which you mentioned probably make us think that the competition law might be equally discussed at the legal forum, at the economic forum, since there is a direct connection. There is no other legislation that would be so closely related with the economy. And I think that the status of an in-house law and the anti-monopoly sphere is increasing each year is seen if we use the examples that are formed in the Russian reality. Our lawyers soon will be ahead of the lawyers in the tax sphere on these matters, and that is also a significant indicator. Dear colleagues, to develop the statements that have been presented by Mr. Genie, I would like to give the floor to Giovanni Petruzzello, who probably will help us to analyze the issues of interaction between the national anti-monopoly departments and the European Union on implementation of the anti-monopoly policy. Please, Mr. Petruzzello.
I think that in the context of today's debate on cooperation among competition agencies, it's useful to share the main features of the cooperation among European antitrust authorities within the European Competition Network. The European Competition Network has been entrusted with an essential function to strengthen one of the most crucial policy dimensions of the European Union, that is, competition policy, by ensuring a close and coordinated participation of the member states in its definition and implementation. I would like to recall some of the essential features of the European Competition Network. First, all the authority of the member state are obliged to apply the same competition rules, namely Article 101 and 102 of the Treaty for the Functioning of the European Union, to restrictive agreements and abuses of dominance. Second, the application of such rules by the European Commission and by the national authorities of the member states occurs within the legal framework delineated by the implementation of Regulation number 1 of 2003. In particular, this regulation foresees a set of common decisional and investigative powers for the competition authorities, as well as a number of new cooperation powers and tools for European enforcers. In the system delineated by this regulation, the European Competition Network has several functions. It is a forum for discussion on competition issues and a platform for informal cooperation. But the most innovative function consists in a platform for formal cooperation in enforcement cases on the basis of the instrument provided by this Regulation number 1 of 2003. It may be useful that I focus on the most silent of said instruments, namely the exchange of informations among antitrust authorities, and then the various forms of reciprocal assistance in investigative activities. The exchange of information among national authorities is essential when allocating a case to the so-called best place authority, and then during an investigation with the aim to establish an infringement. Such exchange of information can take place both in an informal or informal way at all stages of the handling of a case, both before and after the opening of an investigation. During the proceedings, there is a wide faculty for the Commission and the National Competition Authority to provide one another with information concerning any matter of fact or law. Regulation number 1 of 2003 states that not only non-confidential but also confidential information may be exchanged, but under certain circumstances and limits. Then the European competition members can carry out inspection or other investigative activities, namely ask for information or interviews on behalf of each other. This means that the competition authority can gather evidence, even if said evidence is to be collected outside the authority's territory. I think that the main problem which still remain is that we use common tools as regards the substantive law, but we in the different authorities have to follow different procedures. I would like then to stress that the globalization of markets and consequently of anti-competitive activities requires increasing cooperation between competition agencies. While European Competition Network provides an example, a successful example of a regional legal cooperation network relying on special rules, the essential role of other platforms for international cooperation should not be ignored. The International Competition Network, for example, is a forum which favors cooperation in a broad sense as a way to build enforcement capacity, to exchange experiences, and to share methodologies. But I think that we should improve even relationship among other competition authorities like the Russian authority and other European authorities, the Italian one, and I think that we can improve common methodologies, common and exchange exchange information in order to strengthen the enforcement of competition law. Thank you very much.
Спасибо большое, господин Петруцелло. На самом деле,
Thank you very much, Mr. Petrozelli. Indeed, the issues that you raised are highly relevant for probably any state, Russia not being an exclusion. And under the conditions of globalization, following uniform rules from the economic point of view is important, and it means abolishing administrative borders. It means expanding economic freedom and enhancing economic freedom in Russia. Similar processes we can observe elsewhere in the world within the framework of Eurasian space. Suffice it to mention interaction between Russia, Belarus, Kazakhstan, and we're designing uniform rules of competition in this sphere, and the experience of European Union is highly valuable to us. But now I would like to give the floor to Theodor Tanner, and hopefully Mr. Tanner will elucidate some of the aspects of anti-monopoly regulation in Austria. Please, the floor is yours.
Thank you. Thank you very much for invitation once again. Like last year, with a lot of fruitful discussions. I want to try to make it short, that there is enough time for discussion. I think it's useful. So I have 4 points I want to mention. Why do we protect competition? I think this is crucial. The first point. Second point is that we should look at the consumer. It's not for ourselves that we are working in competition affairs. And I will give some examples for good international cooperation and some examples for, I think, effective law enforcement in Austria. This would be my idea. Why do we protect competition? And I've prepared 2 quotes, one from Adam Smith. He mentioned the old problem that people of the same trade seldom meet together, that at the end they are discussing in a conspiracy against the public, or they agree to raise prices somewhere. And on the other hand, Igor Shuvalov, who mentioned 3 years ago at the European Competition Day that encouragement of competition is and will be the key direction of economic policy, the most important factor of modernization of economy. And I think it works, and it's also a value quotation today. So cartels increase prices and decrease quality of goods and service, and cartels damage consumer interests. And there are a lot of studies made by OECD and some universities that prices increase from up to 17 to 27% if there is a cartel in the background. If you look at the advantages of competition, then we can say that consumers can choose from a number of alternative service providers and products. On the one hand, that there are lower prices and new services, which are usually more efficient and consumer friendly than before, and this helps to make our economy more competitive, of course. If you look at the impact of competition on growth, there is a lot of evidence. And let me tell you some examples. On the one hand, that it's a quotation from John Hicks. He mentioned that the best of all monopoly profits is a quiet life, and on the other hand, our job as competition enforcers is not to guarantee this quiet life at all times. And I've listed a second example from the Austrian economy history. We had an extensive market foreclosure for milk and milk products before a EU accession, and prices went down. Let me now come to some examples from the Austrian enforcement. We investigated very hard the Austrian food sector and the food retail sector. We had many complaints about the price diversity between Austria and the neighboring countries. So since 2011 we conducted 22 inspections or down rates in the food retail sector and its suppliers, and we had 2 competitive concerns. The one was the vertical price maintenance. It's a hardcore restriction in our law, and on the other hand there were hub and spoke cartels, and we are trying to settle, of course, these procedures as fast as possible. I think we have two ways of effective competition law enforcement in our modern world. On the one hand, we have the judicial procedures with leniency programs, with inspections, with down rates, with sector inquiries. We have to realize that this is very time-consuming. So I think there is need for shorter and more efficient proceedings also in the European era. And on the other hand, we have to raise the public awareness of the value of competition, of course. We should reach informed consumers, but also informed undertakings, probably through conferences, through speeches, through seminars, through press releases, and through prevention initiatives, of course. So, question is, which mechanisms of impact on violators are more effective? There is one effective tool, it's the leniency policy. We had in Austria about 35 cases since 2006. We have around 5 or 6 leniency cases per year, and the efforts to make the leniency program more attractive and generate more leniency application works very well. We have a very proactive fining policy in Austria, and in connection with ex officio cartel investigations. Second part, down rates and inspections. This seems to be a very effective enforcement tool. We had conducted in Austria in the last 3 years about over 50 inspections in coordination with the police departments, of course. So it's a very effective tool, but it has to be connected, as Frederic Genie mentioned, with the prevention aspect and with the compliance aspect, of course. Let me mention this last point, the value of the international cooperation. We had a very fruitful international cooperation in the fuel sector. We founded 2 years ago, together with FAS, a working group on oil prices and on investigating issues on pricing of oil product markets. At least 17 national competition authorities took part in the discussions which took place in Moscow, in Vienna, in London, and again in Kazan. We discussed the existing approaches to monitoring and analysis, and we exchanged our national experience and our approaches to the application of national competition law in the market of oil and oil products, and the exchange of information on the national cases. And we created a common database for national competition authorities, and we gave a lot of information to our governments and to the European Union. And I think, as you know, European Commission downrated big oil companies in Europe, so 2 or 3 big companies this week, and I think the inspections are going on at the moment. So I think this is really one example for best practice. If you discuss and if you inform and give the information to the right people and to the right and best institution, there will be also results for consumers. And I think this should be one key issue of our work. Thank you for your attention.
Спасибо большое, господин Таннер.
Thank you very much, Mr. Tanner. And the ideas about effective interaction that you've expressed are undeniably useful. And in various markets, we can witness the interaction of a great number of antitrust authorities.
So in this case, when we take oil and oil products, and definitely your remark was extremely interesting for us when you were saying that competition doesn't make our life easy, and I would like to say that it's indeed true, but we're not we're not willing to have this very quiet and peaceful life. Allow me to go to the Russian specifics of the anti-monopoly policy, and allow me to give the floor to Igor Artemyev, who is the head of the Federal Anti-Monopoly Agency. Thank you, Sergei Anatolievich, so very much. And before we talk about strategy and tactics of the anti-monopoly regulation, I would like to react to what Mr. Thanos said. The idea of the Turner is idea of a genius indeed. It's such a simple idea, creation of an information platform at which representatives of different countries represented by anti-monopoly, antitrust authorities provide information on the oil products prices. Actually, this will destroy many of the monopoly prices in our countries, and this is much better than police measures of enforcement. And when we visited Mr. Geny at the conference of the on competition, and Mr. Thanos spoke about this platform, there was a very lively discussion of the potential. And when the representatives of America and Portugal spoke about that and said they joined the platform, then within 2 years it becomes possible to exchange within the on the internet this information and get current prices on oil products all over the world. And then we will just have to analyze how the companies act and how much they decline from this streamline. And this is an effective and simple mechanism which is within the framework of global cooperation, will provide outstanding results. And information we received yesterday that the European Commission initiated cases against Platts and some other companies. And of course, it's a platform that is built as an alternative to the existing models that have been working for 40 to 50 years as indication. So this is a start of a very important work, and over 20 countries are doing that on oil products. This is outstanding and very positive indeed. But on the scale of CIS and with our Italian colleagues, we began to think of why not applying this particular methodology to drugs. 11 countries of CIS selected about 20 life support drugs, and together with Kazakhstan, our colleagues from Kazakhstan and our colleagues from Belarus, Armenia and Azerbaijan and some other countries, we work on a methodology on how to compare these prices and we are talking about that with Mr. Petrocello. Let's have a similar platform for drugs, similar to the one we have for oil products, for the life support drugs. And let's suggest to the countries who would like to support us and join us, display prices on this platform. And the specific feature is as follows. Companies can say, this is our commercial secret, but to the anti-monopoly agency, they cannot say that. And we will publish these prices as anti-monopoly agencies. And this is our mission at the markets, drugs, oil products, and we can extend this list. There can be many platforms of this type, and the issues of international cooperation through transparency will be settled for many people in our countries. And this event that I mentioned is extremely important. The fact that the European Commission actually initiated these proceedings is extremely important. And I would like to speak about our strategy and tactics. First of all, I would like to say the following. The 10-year strategy of the anti-monopoly agency in Russia has been implemented, and we came to the conclusion of this period in January this year. We had set a whole range of issues, problems and tasks for us, and we have fulfilled that work, and we are thinking of the new strategy. What we were planning 10 years ago, we understood that our legislation did not comply with the best practices, that it was quite far away from the point of view enforcement from the European enforcement. So the first step to be taken was to harmonize our legislation. We always realized that discussion of the specific Russian anti-monopoly legislation was not going to work. We first of all said there is no specific way of Russia. There are the best global practices for us. First of all, European practices on cartels, possibly American practices, and that is the way we should follow. And 3 anti-monopoly laws were adopted. The government showed how decisive it was in this point. All the lobbyists did not manage to do much about that. And the first thing we had to do, prepare the new legislation. Then we had to display will and demonstrate that we had very serious intent. And again, the government demonstrated this will, fining and enforcing this, the decisions to take fines on numerous companies, even American companies, that violated our legislation. Everybody realized that it was very serious, and immediately the companies began to hire many more lawyers to work with them. And so nobody today can say that what we're doing is not serious enough. It's extremely serious and extremely important, thus manifesting our power in favor of public interests. We demonstrated we could actually do it. What was important, it was impossible to demonstrate to the judicial system that we were working for the public benefit, could understand what we were doing, why we were doing, and support us. And this did happen after some of the decisions made by the superior courts in Russia, by the arbitrage court, and the plenary sessions of the judicial system. So this was a way to fix, if I may put it that way, what we have been doing, demonstrating that executive, legislative, and judicial power would never, ever support the pro-monopoly, anti-competition activities. And this really happened. And this was a very important step over these 10 years. And so we came to the end of this decade. And what was very important we faced at the end of this decade, that's our anti-cartel actions. 11 cases were initiated against managers of some very important companies in Russia. They are under investigation now, and we will go to the general jurisdiction courts, and criminal trials will begin. So we're following the American tradition in this respect. This also demonstrates how intent we are on what we're doing, and this makes many realize that there is no joke behind what we're doing. So the history of compliances began that Mr. Zheny spoke about. The internal safety and security procedures are very important. That's, of course, in the context of cartels. We cannot avoid mistakes on our part because we are dealing with very serious matters, including custody and so, by the end of the previous year, we have come to the end of this period. We said at that time that the government had carried out the reform in a rather short period of time, less than 10 years actually, and the government was able to overcome all the lobbyists who stood in the way. If you can imagine the strength of our natural monopolies who tried to lobby the interests, then you realize, of course, that that was really a struggle, and our government was able to stand against these monopolies, which wanted to have a sort of a preserve of monopolism in their interests. But the situation is very different from what they expected. So we have new goals, new tasks, which we formulated in 2 major documents. The first document is the roadmap. In December last year, Prime Minister Medvedev approved the roadmap. It's a big document that defines the horizon of our actions and the plan, the action plan, step-by-step plan for the next 6 years. The other document approved by the College of the Federal Anti-Monopoly is the strategy up to the year 2024. Well, of course, they overlap in many respects, and one follows another, but we inform the whole world and we inform our interpreters of what the regulators are going to do. And the government signing the roadmap actually describes what we're going to do in which particular sector and what the methods are to be applied. And so we have two fundamental documents. So of course it will be possible to amend them with time, but allow me to demonstrate to you what we have come to. Within 5 months, what were the decisions made in connection with these documents. And then one more thing I would like to add. 10 years of our life ended with an outstanding result. 3 countries, Belarus, Russia, Kazakhstan, decided to create a supranational anti-monopoly body that would regulate relations that emerge in connection with anti-competition behavior of the companies and officials, companies first of all, on our territories. And moreover, we're getting a sort of a small Euro Commission. It's not exactly Euro Commission, it's Euro-Asiatic Commission. And our colleagues are present here today, and actually they will work with the reverse fines starting with the January next year. As for the roadmap, apart from very general things associated with legislation, we can say that every year we're going to deal with about 5 sectors annually. Yes, and it's aviation this year, and we said we need to take very active measures in aviation, and you will see some of the results. We said we have very high prices on tickets. Let's invite foreign low-cost companies, and EasyJet sells tickets for the summer season at the prices that are 3-5 times lower than the prices of our own monopolists, the prices for London or other cities. Low-costers are functioning. They're operating. Decision has been taken by the Commission on development of competition within the framework of the roadmap. Then we did not like the system of fueling of the aircraft. Usually there was just one point like that at the airport, and they belonged to the monopolists. And we came up with a decision there must be no less than 3 in the cities where there are 5 million people. And Rosneft is building these fueling stations in many of their ports, creating the alternative for those monopolist stations that exist. Lukoil is doing that, and many other companies that will directly sell fuel at the airport. So another decision, a very interesting decision on France and Italy. The most expensive tickets were for Nice and for Paris and for Venice. And they kept saying that that's because Italian and French governments did not want to have extra flights. But that was not true. The problem was with us. And when the government commission decided to change the situation, only then it became possible to change anything. Because we immediately were able to get the support of the French and the Italian authorities, who immediately said, of course, they were greatly interested in getting as many Russian tourists as possible, and decisions to liberalize these routes were taken. And there are 3 companies now making flights to these countries, and the prices went down 50%. So this was done within just 5 months. And of course, we should thank the Italian and the French authorities for that. As for the United States and Germany, the regimen is quite liberalized, and everything is all right with competition and with prices there. So why not address each other in Europe? I'm talking about anti-monopoly authorities, and do something similar to what we did with France and Italy, so that particularly at high season and for charters, we could reduce prices for customers. Of course, it would have been wonderful. Of course, monopolists do not want to lose the markets, but we do want them to lose part of the market. We do want them to get competitors. And we were able to do that in this particular sector. Next slide, 20.2. In communications, we have been debating for 10 years whether it is possible to keep one's telephone number, mobile number, changing the operator. And the answer was negative. And we said that was against competition, and the government decision was made. The companies, of course, will have to lose some of their money, but we are trying to avoid the mobile slavery, as we used to call it. So this is very good for competition. So again, the anti-monopoly authority, if it's just this authority that makes decision, then not much is going to change. But the government commission headed by Shuvalov joined us. Moreover, the new leaders of the Ministry of Communication are against monopoly and for competition. Well, of course, we're also planning to introduce some other amendments to the law on communications. And for 20 years, we, as an authority, have been dreaming of the following. And the government commission and our authority are talking now about the neutrality principle. If you are not specialist in this field, that actually means that if you get frequency, a certain resource that you are using for GSM format, for example, and if there is equipment that enables you to work with the same frequencies, but with new technologies, LTE, for example, technologies, then you won't need any special permissions for that and your licenses for that. With these frequencies you have, you can carry out any type of work you need to carry out. So for competition, it's a breakthrough. This is another roadmap, and all this is being implemented. And another very important topic: medicine and education. I was talking about aviation and now education and medicine. What were the authorities doing in the past? They actually discriminated private medical educational institutions. And when there are subsidies for medical education, the authorities very often do the following. The public universities within the framework of a standard could get much higher substances, while the private schools were getting very low amounts, and we sued for that, and the decision was made that this was discrimination against education and medicine. In St. Petersburg, where we are, the authorities had to change the attitude and introduce the budget changes, and the private companies are going to get as much in subsidies per patient as the public universities. We will have specific cases for all the regions of Russia already, and that actually means that competition in the economy of knowledge in this sphere gets stronger, and we support these initiatives. These are radical decisions, another roadmap. And the next topic I would like to cover is associated with the procurement issues. What was it that we did last year? In order to make accessible for SMEs public procurement, the government and the legislators made a decision on the splitting of the lots. And these small lots, accessible and affordable for small businesses, were sold at the auctions, free auctions in the free market, where bargaining is possible, to 1.3 trillion rubles, 40 billion rubles. So actually, that's how much the government was able to buy from small and medium-sized companies when the lots were split into smaller ones. Every day, there are 5,500 e-auctions carried out through the internet. But the small companies are doing what they're doing, repair works, and the interest rate for them on the normal scale is 20% at banks, but this made it possible for them to get resources free, actually, and we are sanctioning now those who have not contributed into this very important work aimed at the support of SMEs. The information system is there. Of course, you can always check the information and get extra information. Slide 24 is dedicated to another topic. A document was signed together with the Ministry for Energy. And this document includes about 11 legislative acts which are to be enforced, and they actually consolidate the rules of stock trading on the basis of free competition with oil products. Each oil company 10% of their product is to sell at the free exchange, commodity exchange, oil exchange. I'm not going to explain why it is good from the point of view of indicators, but it's also good for independent producers, for small and medium-sized companies. What did the process look like in the past in Siberia? A private owner of a fuel station would say, I need petrol, just sell our business to us, otherwise we're not going to help you at all. So we had to have a lot of cases on discrimination against small filling stations by major companies. But there is no problem now. An owner of a filling station in Siberia can buy petrol at the exchange, and as much as he needs. Moreover, the government decided that all the extra exchange supplies should be declared at the exchange by the oil companies, and thus we have an extra exchange indicator. So for the assessment of the situation with prices in oil products, we have three indicators. Netback, Rotterdam, we have the spot transactions with the product itself, and we have indicators, all the indicators for all the extra exchange contracts and transactions. A very simple answer to the problem. So if a company out of this triangle with its price climbs up too high, then tomorrow we're going to visit them. And everybody knows that. And the judges made their decision and decided what comes after that, because there are already cases, there are precedents and decisions respective. So this leads a very different system of relations in this sector. Then slide 25. 11 cases, as I said. And a very interesting mechanism was established, and investigation group represented by our authority and police. So we have a special body, agency or entity formed by the police and by our agency. It is planned. The operations are planned and are carried out without notifying in advance those against whom we are acting. So this is a mechanism of very strict anti-cartel policy. Now it is manifested structurally, and we're not in courts yet with that. We do not know the reaction of the courts. We do not know what the decisions might be and what the sanctions and punishment might be. But this is an inevitable process, and this year it's going to happen. And for the first time in Russian history, criminally, there will be punished people for cartels, for cartel violations. And coming to the end of my presentation, I would like to reiterate that I was trying to speak about specific examples rather than discussing just the strategy. Well, of course, it's going to be quite interesting for us to know what the reaction is going to be to the roadmap is already published, and our strategy is going to be published. We would like to know your opinion, of course, Mr. Zheny. We would very much like to get your opinion on that. The strategy will cover 11 years, and we would be happy to listen to your comments. But what goes without saying, in the second and in the first document, you will find one very significant element that goes through them, the element of international cooperation. And now I would like to mention one thing that might seem to be unrealistic, but I think in order to overcome cartels, we must aim at the establishment of our own Interpol, bringing together all the countries that are within the competition network. For those who have already criminal punishment for that, it's just a direct option. For the Europeans with administrative sanctions, that's a different story, of course. The cartels very often represent fraudulent actions. And so, after all, they're also criminally penalized. And we can talk really about different forms of fraud. So if we make an attempt to establish this supranational system within the framework of the existing agreements and treaties on anti-criminal activities, but create a specialized entity at the same time with specific rights to initiate investigation of those who are suspected of creating cartels, I think great future could be ahead of us, and we could probably start discussion of that with our politicians, because they do not know where the boundaries of cartels are. We know that there are boundaries, but the countries who are involved in that and the companies from these countries do not react to that, because very often the export cartels are beneficial for the countries, and in many jurisdictions they are simply permitted. But the damage to the global economy is enormous, because these are very negative practices, semi-fraudulent practices, and they are almost legalized at the global arena. I think our joint efforts should be aimed and directed against that. Thank you very much for your attention, and maximal cooperation all over, in all spheres of our joint work. That's our strategy. Thank you.
Thank you very much, Igor Yurievich. I'm sure that after your presentation, there might be a great number of questions, but nevertheless, I would like to announce to all of you that there will be questions. But first, I will give the floor to Oksana Gvozdilova, judge of the highest arbitration court. Thank you. I'm happy to welcome you, and I would like to start my presentation citing from Plutarch. Just horses in a cart run quicker than when they are single due to the competition and rivalry with each other. So what has changed in that time? Nothing has changed. At the last forum, we had just a very healthy exchange of the quotes from Adam Smith, and today it was carried on by Theodore. Thus, in all at all the times, there was competition, and it will always exist. It will not disappear. And I would like to give another quote before we talk about the essence of our theme. I love friends, though not as a Christian. They just amaze me. I have to be on the alert, and I have to catch every word and every intention to destroy the plots. And once I can overturn the building of plots and cunning, that's what I call time. That is from Lermontov, the hero of our time. Nothing has changed. I would like to speak about the fact that today both competition and legislation are at the good stage of their development, and at the last conferences and forums that were held, many colleagues came from the USA, from London, European judges who are dealing with disputes and competition. It shows that disputes that are considered by our courts are similar to those considered by the leading courts of Europe and Russia. In the USA, in Europe and USA, the USA were the first to implement the legislation on competition. A book was published on anti-monopoly religion, which gives the history of development of the American law. And it gives a lot of interesting examples. I have a feeling that it's just happening here now, and it was 100 or 150 years ago in the USA. So each country repeats the examples of some other countries. Since today, many speakers touched upon the theme and raised the questions whether it is better that competition is regulated by legislation. Do we need such regulation? In this book, the author, who was throughout his life studying the anti-monopoly law in Russia, is disillusioned, and he concludes that we should stop that regulation. Probably the market will regulate itself in respect of prices and mergers, and that will be a win situation for the consumers. Of course, I would disagree with that categorically, because no one has an idea that if you catch one thief and if you don't catch another thief, you have to eliminate criminal responsibility because one thief is not punished. But that is not correct. And recently I remembered another story by Jack London. It is called Unexpected, if I'm not mistaken, when a company of gold miners that seemed to be friendly, but finally, one of them wanted to kill everyone else and to take away all the gold. And a woman starts struggling. She binds him, though her husband was paralyzed and he couldn't do anything. And how he puts into life it. There is no police around, no laws. She is just sitting and thinking, we should have a law. And she develops tactics for herself. She binds him and she feeds him, and he thinks how to construct a law so that everything will be rational, and how to punish him because he should be punished because he had shot his friends. And I really recalled it, and I really should say that the law should exist, even if it doesn't sometimes regulate everything correctly, even if the law enforcement practice is not always correct. But we should have regulation, because if we do not have regulation, the competition will be vulnerable at that stage of development. Today, much has been said about it, and there were a lot of interesting examples given. I would like to give some examples from our judicial practice, which is currently expanding, and there is a greater number of the cases on competition at the courts of Russia. They just increase with the geometrical progression. Yesterday I learned that in Austria a cartel court exists. Probably will ask that question later. And communicating with my colleagues, I can say that yesterday there were 2 round tables related with competition, and in the European countries only 2 instances consider such cases on cartels and unfair competition. As to misuse, we have 4 instances, and I represent the 4th and highest instance that considers the most interesting cases. And for our foreign colleagues, I would like to mention it because our Russian colleagues represent the professional audience and they know our practice. I would like to give a couple of examples for our foreign colleagues. Yesterday, we had very interesting cases concerning tenders. For instance, in Moscow, they sold Rublovka forests, and at these auctions, those who wanted to participate in the auctions were not allowed. Even it was very interesting to look at it. And we could watch a cartoon of that presidium, because the third persons were not allowed to participate in the tenders. And where the place where the auction was held, there was no access to that institution. That was a federal institution, and the people without passes were not allowed. The Presidium has considered this case, and it recognized that that was an infringement of the rules of open tenders. The Presidium supported the Anti-Monopoly Service, and recently there was a certain development of that case. Another Presidium meeting was held on forest auctions. That was a bit different, but it also was connected with the rules of open tenders. When a competition was allowed for organizing tenders, if our foreign colleagues do not know, we have long-term vacations for 10 days in our country in January where no one works, and in the forest code there is a 2-week period for publishing the information about the tenders, and the department which organized the auction announced that competition right before the new year when the vacation started, and they completed accepting the applications for tenders right after the vacation. In fact, that was a 14-day period that was observed, but the Presidium regarded that when such a period involves so many days that are not working, the rights of all those who want to take part in the auction are infringed, because in the period of that vacation, and it appeared that only you can do anything just for 4 days and a half to participate in the auction. And one person filed a complaint to the Anti-Monopoly Authority. They had no time to make all the measures, take all the measures, because the banks were closed and the company was closed. The notaries couldn't authenticate the documents. The bank could not give collateral, and even the department that announced the auction didn't work, and they couldn't address there to get some explanation, to receive the documents or to agree on something. And we noted that they couldn't contest it at the court because the court would not receive such complaints within those the 10-day period. And I think that soon the Presidium will pass a resolution on that matter, and the law that determines the 14-day period should ensure the guarantee of all those who want to take part in the auction. And therefore, this is an infringement of the rules of open tenders. So at our Presidium, we considered a lot of cases on misuse of the dominant position in the market of communications, in the market of electric energy. There were a lot of cases at the market of water supply, for instance, at the market of aluminium cans for packaging beverages, and many other cases were considered. We also considered several cases on prohibited agreements, including the market of alcohol, the market of microcontrollers that are PC boards for cashier desk tapes that are used by entrepreneurs in our country. And recently there was a case on Article 11, prohibited agreement of cartel for the foreign companies, and Article 14, unfair competition at the market of domain names. That was a very fine case, and I think that our Russian colleagues are aware of it. That case also provoked a significant response. And yesterday, I liked the statement by Mr. Jenny Frederiks, who said that today intellectual property is more often contradicting competition, which becomes a problem. I would also note that there are more and more cases related with Internet concerning unfair competition and other articles related to protection of competition. And that case on domain names is also quite interesting. Briefly, for the foreign colleagues, I will cover it. The registrate of domain names, one of the registrators, had a preliminary collection of applications, and the date of open registration of domain names was announced, and he collected the applications. He determined the most popular names. As a result, he registered the domain names that were popular through other registrators for himself, and then he was selling them from the auctions. The domain names that were not popular, he just registered them himself for those people who wished to register. As to the popular domain names, he was selling them at high price from the auction. And the Presidium also formulated his legal position, and I think that resolution will soon appear in the internet, and it was stated that the registrar, of course, violated the habits of business proceedings and violated the determined rule, because there was a prohibition on registering domain names, not more than 4,800 domain names per hour for each registrar. There is a principle that the cost of registration should be the same for everyone, and it was not the same, but it was quite difficult, and the difference was tenfold or hundredfold. Besides, there was a conflict of interests of the registrator and the conflict of his functions. Probably the registrar shouldn't register and sell domain names. If he is a registrar, he should register only those domain names for himself which he needs in his economic activity. We also considered the cases on unfair competition at the market of glass cotton. There was an interesting case at the Presidium 2 times ago on commercial concession. Despite the fact that a lot of time has already passed, we can see that in many judicial acts there are references to that statement of the Presidium, and that was due to the fact that one organization which had a trademark of a Peterechka chain that is well known in Russia, the right of using that trademark was delegated to one organization in the territory of the city of Kazan in the Republic of Tatarstan, and the right holder, which at the time of transferring the title didn't have any right, he only had the right to use. And afterwards he acquired the exclusive rights to that trademark, and he came himself to the market of Tatarstan, and an anti-monopoly authority didn't support the Presidium in that case. They made their decision on the basis of the following. Since at the time when that right, what the title was delegated to Aquastor organization, he came to that market in several years, but not immediately. They regarded that these were unfair actions. The Presidium considered that dispute with a different approach, because in Russia the civil code regulates different types of contracts, and particularly such a contract could provide for the conditions on restriction of the rights when transferring the intellectual rights. So a condition could be provided for that the right holder would not enter the market or wouldn't grant the rights to the third persons. Since that right was not provided for, the fact that this organization came to the market of Tatarstan is not a fact of unfair competition. As to other circumstances, they were not revealed by anti-monopoly authority. They just proceeded from the fact of emerging to the market and the interpretation of the contract. I can speak for a long time, but our time is limited. And I can just remember one quote. If you ask the audience of the entrepreneurs what sound is most pleasant in the world, they will answer this is either the sound of the new banknotes or the sound of the body of competitor that falls on the ground. So probably I have to round up my presentation. And the last thing that I would like to stress, the science that is represented here should be investigating the theme of competition. Unfortunately, the scientists are not studying the theme in Russia, and it is good if that theme is developed. It is not so simple. It is more simple to write about the civil code that has been in operation for many years, and there are certain norms. Here it is more difficult, but please, I ask the scientists to engage in the studies of the theme of competition. And I would like to address my colleagues and speakers. If possible, please tell how at your courts of law you consider these cases related to competition. And probably there are some interesting judicial precedents. And a short question, how do you regulate the market price? Because with us that problem is quite extensive in Russia. And the notion of the market price is present in the customs code, in this tax code, in the law on competition. Probably these notions should be brought to a single denominator. Is everything regulated in different way in Europe, or do they have the notion of the common market price? Probably they can use the expert examination. And the last, I would like to thank the Anti-Monopoly Service for the fact that they have introduced the warning procedure in the last package. I think that some cases will be moved and it makes life easier for the business. Though another problem appeared also concerning the consideration of the disputes on warning at the courts of law, and probably they will be soon also considered in the Presidium. Thank you very much, and I'm ready to answer your question. Thank you very much, Oksana Yurina. The questions which you are raising will be discussed during question and answer section. Since we have no time, we should give the floor to all the speakers, and today we repeatedly raised the question of integration. Integration processes, of course, in the modern global world are quite important, and it is with great pleasure that I would give the floor to a chairperson of the Agency of Kazakhstan on protection of competition, Kuandyk Bulandyk Bayanovich. Thank you.
Good morning, dear participants of the round table. I would like to express my gratitude to the organizers and for good work. So all the questions that are being discussed are highly relevant for Kazakhstan, and especially now when Kazakhstan is planning to join the WTO organization. Then they're actively going on mergers and acquisitions create a threat for the emergence of monopolies. Потому что просто я не могу разобрать практически. У нас sorry, there is a technical problem with the sound. So now the legal foundation for the interaction between the CIS countries is the agreement as of 2000, the year 2000, that was signed about the coordination of antitrust efforts. Then it, as a follow-up, there was an agreement of, it was a follow-up of the agreement of 1993. Then the Interstate Committee on Antitrust Policy was established, which then became one of the most efficient bodies in this area. Currently, 38 meetings of this committee have been held, and this interaction is implemented on the basis of the headquarters, and a lot of efforts are based on the decisions of this committee. So the focus of the committee is on the socially significant markets for the CIS citizens. Last year, we did monitoring and price investigation in the pharmaceutical sector in CIS countries. In Kazakhstan, a number of violations have been revealed, we realized that we have no clear definition about the substitutes in pharmaceutical sector. Insufficient cooperation between the medical doctors community and the medicine producers community. A great number of intermediaries and distribution channels make hindrances. Then the report was directed to the ministry, and the decision was made to coordinate the efforts and to design the more robust legal foundation. Then you heard about the customs union, which created new opportunities for the interaction between antitrust bodies. Thus, in Belarus, Kazakhstan, and Russia, this body has now the right of asking for information, and they are mandated to exchange information. FAS and committees on competition enforcement and conducted investigation of telecom operators, and the tariffs on international roaming were too high, unjustifiably high, which was result of the collision between Kazakhstan and Russian telecom operators. So quite a few telecom operators do that. And this was qualified as abuse of the dominating position. And this pushed Kazakhstan and Russian telecom operators to lower their international roaming tariffs. According to the results of the investigation of international roaming prices, voice message tariffs were decreased 1.52 times, SMS messages up to 10 times, internet 6 times for 1 megabyte. Similar decrease of prices on international roaming, according to the information available to us, have been accomplished in the Russian Federation as well. Right now we are tackling the issue of the transfer of the telephone number when changing telecom operator. This is highly relevant. Then, talking about the cooperation between competition bodies, we are now discussing the creation of the uniform platform for information exchange, especially on socially significant markets such as the pharmaceutical market. As Mr. Thaner said, and as Mr. Artemyev supported, this is another highly relevant issue, and we rely great hopes on this platform. We believe it will become a cornerstone for holding well-coordinated work in controlling the growth of prices and justifiable growth of prices. Antitrust bodies will be enabled by this platform to exchange information promptly, information on the status quo in the goods market. This will enhance the price monitoring and cooperation in this regard. Then, parallel import issue is another issue of concern. Article 16 on the defense of the intellectual property, adopted in 2010, envisages prohibition on parallel import. At the same time, the enforcement of this norm creates limitations for competition and trade, which infringes the rights of consumers. In this regard, antitrust bodies of Russia and Kazakhstan have initiated the change into Article 13 of the said agreement, and currently this issue is being considered by the Eurasian Investigation Commission, and we are hopeful for the positive resolution of this issue, which will strongly impact the development of competition. At the same time, in Kazakhstan, we are currently having active housing construction, which is important for the construction materials markets. And for example, on cement, some high monopoly prices were traced, which in the long run leads to growing prices on housing. So here, the experience of our colleagues would be very important for us to know about what preventive measures can be undertaken not to allow such an increase in prices. Not once we have seen when the government would declare one program, like, for example, intensification of housing construction, expanding the market of housing construction, but this is immediately picked up by the business community, and they immediately artificially raise prices on construction materials, creating those supply chains with inflated prices. For us, it's a very painful point, and it would be highly useful if our colleagues could share their experience in tackling issues like this. The Agency on the Protection of Competition plans to continue cooperation with antitrust bodies, not only within the framework of the Customs Union and the Eurasian Agreement, but also we would like to cooperate with antitrust bodies of other countries, because we want to protect competition. We see it as our high priority goal. We will follow the principles of fairness, openness and justice, and last year, more than 50 investigations of goods markets on 146 product groups have been accomplished. Well, we believe that our experience from this investigation will be of interest to our colleagues from the Eurasian Union. Another relevant issue in competition protection is that of reforming the spheres of the natural monopoly. The legislation of the Republic of Kazakhstan, here we have 13 areas of natural monopolies, including 49 activities. At the same time, the government of the country sets the goal of reducing the sphere of natural monopoly through stimulating competition on the goods markets. Here we explored the experience of Russia, Ukraine, Belarus, and other countries, and the spheres of natural monopoly in different countries are different, even though the system and approaches are the same. So we have a plea to our colleagues for this in this area. Since we are now actively tackling this issue, if you have any practices or anything that you can share, please help. Currently, within the framework of the Uniform Economic Space formation in Belarus, Russian Federation and Kazakhstan, Eurasian Commission is designing the model for the draft law on competition. The legal regulation of the economic policy. We hope that the adoption of those antitrust laws and competition laws, and by the way, they are to be adopted by July this current year, this will enhance the cooperation with the anti-monopoly bodies of the cross-border countries, neighboring countries, Eurasian countries, and the European Union countries. So, soon we are going to have a conference in Astana, the capital of Kazakhstan, on those relevant issues described above. Moreover, in 2 years, within the framework of the Sixth Economic Forum, we'll have a roundtable, the development and transformation of economy through fair competition, and representatives of CIS and Western countries will be present. I would like to invite you to attend this conference. This roundtable will enable us to design uniform approaches in the cause of protecting competition. I wish you fruitful work. Thank you. Thank you, Bulat Bayanovich.
Thank you very much, and we pass on to the last presentation. I would like to give the floor to Larisa Vyacheslavna Kalanda. She will present the vision on the trend of anti-monopoly policy with the eyes of business. She represents one of the largest of oil majors in Russia. Good morning, dear colleagues. I will dwell on some problems that are important for business and society. First, compliance of the provisions on pricing to anti-monopoly law. Recently, I have outlined it as a problematic issue. It was outlined by Oksana Yurievna. Today we are in a paradox. The tax and anti-monopoly legislation provides different requirements to the prices established by economic entities. It is a real situation when there are no claims in respect of FAS. When it is okay, might be regarded as lower by tax authorities or vice versa. The methods used by the tax and anti-monopoly bodies in accordance with the tax code and federal law on protection of competition differ, and hence the difference in approaches results in risks and different assessments of the actions of economic entity in the same situation. I will give some examples. For instance, the price is determined in accordance with the order of the anti-monopoly authority. According to anti-monopoly legislation, the infringement will not take place in this case. At the same time, from the viewpoint of tax regulation, we have to compare it with the market interval, and probably additional tax will be charged. Secondly, the price is determined based on the stock exchange tenders. According to the anti-monopoly legislation, such price might be recognized as monopoly high. From the viewpoint of tax law, it is tax regulation, it is a market price. Another example, when based on results of commercial negotiations, different prices are set for the same commodity sold at the filling station. At the refinery. From the tax legislation, such situations regarded as discrimination. As for tax regulation, if there is subsequent localization, this is possible. Hence, we suggest to develop amendments to the tax code that make it possible to approach the methods of price control of prices to operations at the internal market of the Russian Federation and the rules for determining the high and low price. The second problem that I wanted to outline was also mentioned by my colleagues in the course of the panel discussion. This is a problem of proofs in the judicial process. Judicial practice on anti-monopoly disputes makes it possible to state that the procedure of assessment of sufficiency and permissibility of the proofs is not duly regulated. Being guided by internal orders and instructions, FAS organs form their economic proofs based on market indicators, which in the judicial process cannot be duly checked. As a result, most provisions of the law require a deep economic analysis. The law enforcement practice uses only formal features determined by the anti-monopoly body, and they draw the conclusion on the violation. And economic entities have no possibility of independently determining the market for assessment of the risks, because only anti-monopoly body has the authority to require the necessary information, can determine the doubtful provisions of market analysis. In law enforcement practice, there is no possibility of independent economic analysis or expert review. Therefore, we need to determine by the laws the requirements to proofs on anti-monopoly cases and to determine the mechanism of market studies. It would be also useful at the level of the law to determine the procedure of requiring by FAS authorities documents and information and the procedure of giving responses to FAS requests. Today, there are no restrictions in the law, in the right of anti-monopoly authority to get the information on the legal entity from the viewpoint of grounds for receiving information and form of its presentation. The authorities of other controlling bodies, including law enforcement and tax bodies, are not unlimited. They are related with the laws. The provisions of legislation on monopoly high price also results in problems of proofs because the norms of the high monopoly price is not determined and we cannot determine the criteria. It is necessary to establish more simple rules of determining the monopoly high price, and we need to impart to the stock exchange indicators the status of price provisions. And there is a legal base for that, as was mentioned by Igor Yurievich Artemyev. Just a few words about the roadmap. It was also mentioned in the presentation by Igor Yurievich. A set of measures on the roadmap adopted by a resolution of the government is aimed at development of the system of private law enforcement. In anti-monopoly law of Russia copies the American system of private cases in antitrust. But, however, disadvantages of that are not taken account and no measures are taken for protect against ungrounded risk. Most of the EU countries think that the reception of the American system of private law in antitrust is impossible, and institution of the Institute of Multiple Losses together with the combined cases might result in higher risk for the business and low investment activity. This result doesn't comply with the purposes of development of competition and the growing number of new companies. The Institute of Multiple Losses does not agree with the sanction for infringement of anti-monopoly legislation, and it might result in dual punishment measures. Generally, the system of private cases can and should be developed so that it wouldn't create the incentives for misuse, wouldn't harm the development of economy and competition. Taking into account I would like to say a few words related to the development of the single anti-monopoly legislation under the Customs Union, Republic of Belarus, Kazakhstan, Russia. Due to the continued work on the model of the law on competition, I would like to draw the attention of the developers to the matters how and in what order and on the basis of what criteria the dominating provisions will be determined and the facts of misusing it at transboundary markets. Who will develop these procedures, since the approaches of the countries of the Customs Union to this matter are different, which was also mentioned by our colleague from Kazakhstan. Determination of the legal definiteness on these matters is quite important for larger Russian holding companies from the viewpoint of understanding the circulation goods and assessing their status within the common economic space. Thank you for your attention. Thank you, Larisa Vyacheslavna. And since Larisa Vyacheslavna and Oksana Yurievna mentioned some questions concerning market pricing, since we have a limited time, I would like to briefly ask Mr. Zheny, what are the approaches to determination of fair market prices, and then we'll give the possibility of the audience to the audience to ask questions, and the ratio of different relations of different systems of regulating anti-monopoly customs. Is there any uniformity in that field?
Very briefly, because this is quite a technical issue, of course, but the spirit in which competition laws are applied is not to regulate directly the price when it can be avoided, when a competitive mechanism can be installed. So the competition authority's first attempt is to try to promote the competition by facilitating entry, by eliminating any kind of interdependency in decision making, so that the price that will emerge will, naturally speaking, be a competitive price. So the first level of reflection is how can we set the general conditions that will naturally lead to a competitive price. Now, in some industries, where there is an essential facility or where there is a natural monopoly, it is just not possible to promote this approach because competition cannot set in. Now, those cases are usually exceptions in the competition law where it is acceptable to have a direct regulation of the price because there is no possibility of a competition mechanism. It's not always the case that the competition authority itself is in charge of this. Very often it is a sectoral regulator, like the railway regulator, the electricity regulator, or the, whatever the sector is. What is an important consideration is the relationship between the competition authority and the sectoral regulator. In many countries, and this is more and more of a tendency, a dialogue is created between the competition authority and the sectoral regulator, and they inform each other of their respective goals and their respective problems. For example, the competition authority says, I have a concern about the fact that the pricing is very high in this sector. I cannot bring competition through my own instruments, but I would like you, the regulator, to look at the issue and use your technical knowledge of the functioning of the sector, possibly to regulate the price in a way which is going to be useful. If I take the case of France, or I could also take the case of the United States, for example, there are mutual exchanges between the sectoral regulators and the competition authority, which are designed to facilitate this decision-making process. So that was the first question. And the second question, I think, was on the cooperation. How can one make systems more compatible? A lot of what has been said here today is very important, which is the establishment of cooperation between systems. And the second part is the establishment of best practices that countries tend to follow. And the combination of those two mechanisms is a virtuous progress towards having a more seamless international system. Now, Mr. Artemiev, however, said something very important. As long as there is no multilateral framework for competition, there may still remain gaps. And he took the example of export cartels. Even if every country had exactly the same law, even if every country cooperated, there would still be legal difficulties to get at export cartels because they have an effect outside of the jurisdiction where they are formed. And this is complicated, which is the reason why there has been not only efforts at the regional level, which are very important, but also possible talks of establishing a multilateral enforcement system. The example of the European Union is a good example where, as Mr. Tenner, was said earlier, the national competition authorities all apply both their national law and also the supranational law. We are not yet at a stage where this system could be extended throughout the world, but it is something that we will have to face. And in the meanwhile, the kind of cooperation which was described is absolutely essential. And the fact that it starts at the regional level is fully understandable. There are fewer participants, so it's more manageable. It's very often countries that share the same history or the same legal system, so it's easier for them to establish cooperation, and also it is more efficient because very often they trade quite a bit with each other. So this is the way forward: best practices on the one hand, cooperation on the other hand, at the regional level, and hopefully there will be a higher level of cooperation later on.
Спасибо большое, господин Жени.
Thank you very much, Mr. Genie. Your comments, please. I will try to be brief. Really, in Russia, there are some different approaches on the fair market prices in the customs legislation, in anti-monopoly legislation. In order to be able to change it, some time ago we set up a working group with the tax inspectorate, and now we are starting the dialogue on unification in that sphere. When Larissa Vycheslavna says that the companies appear to be in a difficult situation, and what tax authorities regard as an infringement, we do not regard, and vice versa. There is a deadlock for the company which doesn't know what practice to apply, and the conflict arises mostly when the tax authorities call transfer prices reduction of the prices, and they are responsible from the viewpoint of tax authority. And so when we start to sell abroad more cheaper, we might call it a discrimination, because some companies are discriminated by the monopoly with respect to other companies. These problems have to be solved. Previously, we had the problem on unification of approaches, and we have the single legislation. We have a commission with the Central Bank of Russia, and we cannot demonstrate different approaches in respect of determination of the work of the credit institution. We have a similar commission with Commission on the Securities, which works as a single authority, that is a decision-making. So there is complete unification of the practice, and the new law on the defense order sets up such joint commissions of the order of regulation of the customs order, because their items are quite specific there, the city competition is poor. There will be no different approach, but we have to develop the unified approach of the customs inspection. That is one of the fundamental tasks to be solved in 1.5 years, and the fact that was mentioned by our colleagues is quite good. Now we are running out of time, but if there are two questions from the audience, you are welcome, please. And to add to what has been mentioned by Larissa Vycheslavna, representative of Rosneft, and presentation of the documents. From my experience, I can say that there was a major step forward under the third package when the administrative code, a sanction for untimely presentation of documents was introduced to the administrative code, because previously the situation was such that the unfair subject in the face in the person of monopoly ombuds were interfering with the state without presenting the information for many months, and when a certain and no court proceeding started. When there is a sanction for untimely presentation of documents, now the situation is ordered. As for the important issue on the limits of filing the request, that will be reflected in the model anti-monopoly law, I'm sure, that will be approved in the framework of the Eurasian space. Thank you for your comment. Please, question. Gazpromneft, to colleague Larissa Vycheslavna, taking the opportunity. Larissa Vycheslavna mentioned in the roadmap there is a trend for transferring the anti-monopoly legislation to the civil plane, so collective claims and so on. We are reading your draft project for 2014, and we see that there is an enhancement of the administrative functions, and only disqualification remains as a sanction. So that's your plan. So what is the trend in reality? Would you like to strengthen the administrative component, or would you develop the civil law means? I don't think that will be able to combine everything. Thank you for highlighting that theme. Having analyzed the experience of the United States, we concluded that under our conditions, super monopolies in economy, we have to develop the system of private claims or private cases. We have to set up the popular fund against misuse of the monopolies, as I call it, or at the same time we have to think as to what is being done. Probably we shouldn't strengthen, but we shouldn't soften our sanctions. The Institute of Private Claims is very complicated. For our legislation, if we want to inscribe into our legislative tradition that element, that will be too difficult, but we should try and do it. Moreover, among our advocates, we can see real engines which would work here well without participation of the public authorities, finding law infringements on behalf of the monopolies and making these monopolies paying fines and forfeits to the consumers. This is also due to the fact that we have a representative office in each region, but only the capital of the regions. I like that example with Krasnoyarsk and Norilsk, when our agency is at Krasnoyarsk, in 5 kilometers, the town of Norilsk is located, and no one has ever visited it. And in small towns, no one ever came. I mean, an anti-monopoly worker. So we are in a very limited space, and advocates, good lawyers with good legal education will make the monopolies work hard. So we want to fry you in a pan, so to say, so that your life would become more funny, you will get a good salary, good education, and you'll manage that popular front if you behave well, if you do not infringe the violation. If you violate, you will be punished. But there are some risks. The American practice, which we are going to analyze actively, will analyze in Green Whale or some negative consequences. We have to provide such a legislation on private cases to avoid these difficult examples. Mentally, for the Russian citizens, it is not suitable. Thus, that will be an emergency. Even in case of the divorce, people suffer. And if money or property is involved, that is emotionally difficult for our citizens. So we should have a very balanced approach against negative shows, but as an option, we would like to support the Ministry of Economy as well to create a system of private claims with multiple compensation as in USA for 2 or 3 years, probably 1, 2 or 3, probably in 5. We'll see. No microphone. Can't translate what is being said without the microphone. It is too early to talk about it now. But for our foreign colleagues, I would like to mention that you have a developed competition. If someone starts to increase prices, you will just go and buy from another person, not from the French, for instance, from a Dutch or from the German company. In Russia, at our local markets, you won't be able to buy anything. If it is a monopoly, that will be 100% monopoly in Siberia as well. If you go to buy commodities somewhere, it will not be good for you to buy it, and the price might be 3- or 4-fold. So in Siberia, the system of communication is not as well developed as in Moscow and St. Petersburg, but we have to find the lawyer who will be able just to protect the population of the city. In case there is a hooligan tariff, they will receive a compensation. So we have made a serious conclusion, and the government signed the roadmap and said that we can work. But we want to have know your hazards, because we don't want to create a naval system that will not be controlled of assistance of city madmen who will persecute our companies with their claims. So we have to show respect to our companies, to natural monopolies, so that they will understand the rules of the games. Otherwise, we'll just fail. Thank you very much, Igor Yurich, for your optimistic comment. Our time is up, and I would like to give the last floor to Mr. Genie.
Just on a very short point, but a very important point which has been mentioned, the necessity to have consistency and complementarity between different laws or different regulations that may have an impact on competition. And we've heard certainly two examples which have been mentioned. One of them was on the tax law, whether there was consistency between the tax law and competition law, and the other one was on public procurement and competition law. I was very much impressed by what Mr. Artemiev said about the desire to make the laws more consistent and to establish a joint working group between the tax authorities and the competition authorities. And I must say that this problem is also a problem that we have in the European Union. For example, I can give another example, the tension between securities law and competition law. Securities law usually require firms to give a lot of information about their future strategy. Competition law doesn't like exchange of information about future strategy. So there is a need there to get consistency. So this is a really important function, and I can see that FAS is very active in promoting better consistency between better competition law, and I think that this is extremely good for the system. It's a long process, but it's very useful.
Thank you very much, Mr. Genie. I would like to thank all the speakers who brilliantly characterized all the finance and peculiarities of anti-monopoly policy in different countries in Europe and Kazakhstan. I would like to thank the audience who, despite the early time of the start of our conference, have come here, and I think that they have learned a lot, and let's applaud to all of us. Thank you.